Two or more companies represented by separate attorneys often want to coordinate on strategy and share information, but to do so in confidence. In many cases, companies look to a joint defense agreement, or more accurately, a common interest agreement. When can such an agreement be used, and what are the benefits and risks? That's today on Liability Watch. Welcome to Liability Watch. I'm Susie Higbee. A common interest agreement can be useful, but courts don't uphold them in all situations. When do they work? How much protection do they offer? And what risks do they entail? Today we will hear from Chip Magid, a product liability attorney at Dorsey & Whitney, LLP. He'll discuss the hows and whys of common interest agreements. Chip?
Thanks, Susie. A common interest agreement, sometimes called a joint defense agreement, although the principle applies equally to plaintiffs working in common and to parties not in litigation, is a means of extending the attorney-client privilege in the work product doctrine to two or more parties, represented by separate counsel, who wish to work together toward a common legal goal in confidence. To work, four conditions must be met. The parties must have a common legal interest. The parties must intend to keep communications amongst themselves confidential. The underlying communications must themselves be subject to the attorney-client privilege or the work product doctrine. And finally, the communications must be among lawyers for the parties, not the parties themselves. Those elements deserve a bit more explanation. First, the parties must have a common legal interest. It is not enough that Party B has an economic interest in the outcome of Party A's litigation. So, for example, just because two parties have an interest in the same outcome of litigation or regulatory action, they don't necessarily have a common legal interest. The courts are all over the map in terms of how common the legal interest has to be. Some courts say that the legal interest has to be identical. Other courts say nearly identical or substantially similar. The legal interest usually involves litigation, but not always. It can apply in the transactional context. And in the case of litigation, the litigation can merely be threatened or anticipated. It doesn't have to be extant. Next, the parties have to demonstrate an intent to keep their communications confidential. That's where a written agreement comes in handy. Although a written agreement is not required for the common interest doctrine to apply, a written agreement helps immeasurably as proof of intent and as to when the parties first intended to keep their communications confidential. Third, the common interest doctrine does not establish a separate privilege. Any communications must qualify for the attorney-client privilege or the work product doctrine to remain confidential. The only difference is that disclosure within the common interest group is not considered a waiver. Consequently, purely business advice will not be protected by a common interest agreement. Finally, the communications have to be among the parties' lawyers, not the parties themselves. In most cases, the parties can be included in the discussions, but communications solely among non-lawyers do not qualify for common interest protection. There are a few special considerations worth noting. The law concerning the extent of the common interest doctrine varies widely by jurisdiction. If you're going to enter into a common interest agreement, and particularly if you're going to specify the applicable law, make sure you know what that law is. A common interest agreement will protect documents and information from disclosure to third parties. But absent a specific agreement to the contrary, if the parties to the common interest agreement later turn on each other, the information is not privileged as between the parties themselves. A common interest agreement is generally not discoverable, but the fact of such an agreement is discoverable and is admissible to show bias. Finally, a common interest agreement can create an implied attorney-client relationship. It's important that any agreement make it clear that each party is represented by its own counsel and that the agreement disclaim any creation of any fiduciary or attorney-client relationship. A common interest agreement can be an extremely useful tool in multi-party litigation. Done right, it can make litigation more efficient and less expensive. But pay attention to the details and make sure that you don't inadvertently create a relationship that you don't intend.
Thanks, Chip. To request a copy of Dorsey & Whitney's no-cost guide to common interest agreements, follow the link on your screen. If you'd like more information about Dorsey's safety audit and litigation prevention solutions, contact Chip or visit dorsey.com. I'm Susie Higbee for Liability Watch. Thanks for watching.